Hi guys, and welcome to another episode of Kabir Considers. In this video, we're going to react to the top 10 court cases that changed America. Now, there have been obviously many thousands of court cases that happen in a country like America. In every country, every day, there's hundreds of cases, but there are particular cases that maybe they set precedents, they cause changes in the law, either because of how serious the crime was, or perhaps because, such a thing had never happened before in that particular way. So the judge had to devise a whole new way of dealing with that particular case. So ones that probably come to mind, I'm trying to think, perhaps the OJ case, maybe, I don't know, because of how long it took the jury to deliberate and come up with the verdict. But I'm guessing it's probably things to do with like food, maybe, or like kids' toys, perhaps. Because I remember hearing about a kids' toy product. It was like small beads that they had to ban because it proved quite dangerous. So yeah, this will be an interesting video. And by the way, guys, if you enjoy my videos, please help me out by hitting the like button, subscribing, and turning on post notifications.
Former NFL star O.J. Simpson charged with his ex-wife's murder. And again, it was the trial of the century.
It's the law of the land, and the land where nothing is more important than the law.
But the debate over Bush v. Gore goes on to this day, not least among some of the justices themselves.
Welcome to WatchMojo.com, and today we're counting down our picks for the top 10 court cases that changed America.
The Supreme Court in 1824 provided an answer within the framework of a case known as Gibbons versus Ogden, or more simply, the Steamboat case.
For this list, we're looking at court rulings from the United States that had a significant historical impact in shaping the country that exists today. Now please take your seats. Court is now in session.
Court has just ruled part of that law is unconstitutional. This is being described immediately now as a big win for advocates of gay rights.
Number 10, Bush v. Gore.
For the last 80 years, the Florida court has always ruled that the right to participate in the democratic process is more important than a voter's ability to follow instructions.
The 2000 U.S. presidential election resulted in one of the most controversial and divisive legal decisions in the nation's history. In Florida, the vote was deemed too close to call, and the Florida Supreme Court called for a recount. But the United States Supreme Court overturned the order and sided in favor of George W. Bush, effectively declaring him the next president, which caused concern for many critics who believed the court had overstepped.
The standard is whether or not the intent of the voter is reflected by the ballot.
Gore lost with grace, but after the events of 9/11 and the War on Terror, many wondered what would have been in store for America had the court decided differently.
But the debate over Bush v. Gore goes on to this day, not least among some of the justices themselves.
Number 9.
Oof, that's an interesting one. I feel like maybe they should have allowed the recount. I get why the court didn't want to set that precedent, because then you could question the outcome of every presidential election. But maybe they should have did the recount. What do you guys think?
Obergefell v. Hodges.
Now gay marriage is back at the court. And this time, it deals with if states have to recognize their legality.
While many countries around the world have embraced same-sex marriage for years, it wasn't until 2015 that the U.S. Supreme Court legalized the right of people of the same sex to marry, making it a fundamental one.
There was a glimmer of hope among the advocates for same-sex marriage under the law that Chief Justice Roberts might find his own path.
Named after James Obergefell, a man who sought to have his marriage to another man recognized in Ohio, the Supreme Court ruled in a 5-4 split that same-sex marriage was legal under the Constitution's 14th Amendment. Citing the amendment's due process and equal protection clauses, the case overturned the 1971 ruling against same-sex marriage in Baker v. Nelson.
In 1970, they'd applied in Hennepin County, but were turned down in a case that eventually went to the state Supreme Court, where they lost.
Number 8, Marbury.
Wow, 5-4. That is super close. That last person, you know that they were just, potentially thinking about it, deliberating for a long time.
Marbury v. Madison.
Literally, the last day of Adams' presidency, he was busy signing commissions for these federal judgeships.
This case was of vital importance to American history, as it declared that the U.S. Supreme Court had the authority to overturn laws made by Congress, and, perhaps more significantly, awarded it the power to interpret and lay down the law.
The upshot of the case was that Chief Justice John Marshall ruled that the court had the power to review, uphold, and strike down executive actions pursuant to the Judiciary Act of 1789, and in doing this, to strike down part of that federal law.
In this case, the court unanimously sided against Marbury, who had brought forth a case petitioning for the court to force the Secretary of State to give him an appointed position that had been promised to him by the previous administration. The decision stated that the law allowing the Supreme Court to do so was unconstitutional and therefore would not be honored.
President Jefferson won his battle against Marbury and his companions. They never received their commissions. Chief Justice John Marshall, however, won the war to establish the Supreme Court as the final arbiter of the meaning of the Constitution.
Wow.
Number 7.
So that was the genesis of the Supreme Court. That's how it came to be. I love finding out how things like that, you know, like things like the Magna Carta, those monumental things that kind of become mainstays of a country.
Citizens United v. Federal Election Commission.
Vote for this guy!
Vote for this guy.
Aren't you tired of this stuff?
Acknowledging the disproportionate influence that corporate money can play in the outcome of political campaigns, the U.S. had sought to control what was termed electioneering communication. The radical decision in Citizens United v. Federal Election Commission reversed that trend. Leading up to the Democratic primaries in 2008, conservative lobbying group Citizens United wished to run and advertise a disparaging movie about Hillary Clinton.
We all know we're going up against some pretty powerful forces that will say, do, and spend whatever it takes to stop me and stop you.
The Supreme Court decided they could. With this decision, the Supreme Court granted the same First Amendment rights to corporations and unions as to individual citizens.
Free speech,
the subsequent rise of super PACs has allowed wealthy corporations and individuals to attempt to influence elections in a manner that may have serious and far-reaching repercussions.
And after today's ruling, the corporations will only need a few more years of inflaming people before the message suddenly shifts to everything's great.
Number 6.
Yeah, I think it's potentially undemocratic that companies can just pump money into political campaigners and political candidates because, you know, the incentives for a company might not align with those of the people, but because, you know, they can just buy that influence, it's kind of unfair. Like, what do you guys think of that? Should companies be allowed just to, you know, pump millions and millions of dollars into political candidates? What do you guys think? I'm not sure.
New York Times v. Sullivan. Back in the 1960s, the New York Times made a mistake, effectively stating untrue facts about the police force of Montgomery, Alabama, in relation to Martin Luther King Jr. and the Southern United States civil rights movements.
An editorial writer named Grover Hall for another Montgomery paper saw that and wrote an editorial where he called it lies, lies, and lies.
The police commissioner, L.B. Sullivan, sued them for libel, a form of defamation. However, the court ruled in favor of the New York Times, stating that a free press is necessary for a free country. This case set the precedent that in order to be found guilty of defamation, one must prove that there was an intention to harm, known as malice. Number 5. Dred Scott v. Sanford.
A black race has, for more than a century, been regarded as beings of an inferior order, and they have no rights which the white man is bound to respect.
This is the story of Dred Scott, an African-American slave who moved with his owner to a free territory. After the death of his owner, Scott was inherited by his former owner's widow, and he attempted, unsuccessfully, to purchase freedom for himself and his family. He filed a lawsuit, however, stating that as he lived in a territory where slavery was outlawed, he was entitled to his freedom.
Which makes perfect sense to me, obviously. I mean, like, to be honest, the whole concept of slavery is just insane to me.
They pointed to colonial law. It's in the text of the Declaration of Independence and Constitution. The Fifth Amendment says that no one can be deprived of life, liberty, or property without due process.
The Supreme Court's decision stated that all African Americans, free or not, were not considered American citizens, and therefore had no right to bring about a lawsuit. This decision is consistently listed among the worst in the history of the Supreme Court.
So essentially, the procedural basis on which they lost was that they were citizens of nowhere.
Number 4, United States.
Just to think that you could own a human being, you know? Make them do things they don't want to do just because you own them. It's bizarre, isn't it? Like, it's crazy to me.
States v. Nixon.
I'm saying that when the president does it, that means it's not illegal.
Nixon actually said that. And the Supreme Court said, well, we'll just have to see about that. The Watergate special prosecutor subpoenaed Nixon to hand over several documents as evidence, specifically tapes he had recorded. Citing executive privilege, Nixon refused. The case went down in history as the Supreme Court placed clear and defined limits on how far the president could go with regards to executive privilege. The case set the groundwork for what would ultimately end in Nixon's resignation, 16 days after the court handed down its decision.
I shall resign the presidency effective at noon tomorrow.
Number 3, Miranda v.
Just insane, you know, like, it's not really insane, but it's just interesting how one bad decision, I suppose when you're the president, you are held to the gold standard, but that one decision cost him, you know, the presidency. Ouch.
Arizona.
Go ahead. It's 4 declamatory sentences followed by a question for a total of 57 words.
Okay. Look, it obviously starts with you have the right to remain silent. I know you've heard this before. And then, I think it sounds something like,
The famous Miranda rights are named after Ernesto Miranda, who confessed under police questioning to a horrible crime. However, at no time had Miranda been informed of his right to remain silent and to have an attorney present.
It's an idea so obvious, you can't believe there was ever a time that we didn't have it.
While the Arizona Supreme Court ruled that Miranda's confession was admissible, the U.S. Supreme Court disagreed. This not only set a valuable precedent, but also gave countless cop shows the familiar phrase, read him his rights.
His rights. Twice.
In terms of the rights of criminals, Miranda v. Arizona built on the earlier trial of Gideon v. Wainwright, which stated that all defendants had the right to legal counsel.
Here is what we said. An accused person cannot effectively defend himself. Without counsel, the accused cannot possibly evaluate the lawfulness of his arrest.
Number 2, Brown v. the Board of Education of Topeka.
Yeah, I mean, so that's where Miranda comes from. I always wondered, why is it called the Miranda rights? I thought maybe the word Miranda actually had a definition in the dictionary.
The 1896 court case of Plessy v. Ferguson was a troubling one, as it was that case that declared separate but equal standards to be right, effectively legalizing segregation in the United States.
The Plessy decision introduced a new phrase into the language, separate but equal. 21 states would soon pass segregation laws under the protection of Plessy.
It wasn't until 1954 that several parents went to court again, making the case that separate but equal was a myth, and that African Americans were being treated as second-class citizens.
We conclude that in the field of public education, the doctrine of separate but equal has no place.
The court unanimously ruled in the parents' favor, stating that the Equal Protection Clause of the 14th Amendment made separate but equal unconstitutional, proving to be a landmark win in the history of the civil rights movement.
I felt so validated. It was pure joy to go into that classroom for me. I mattered.
Before we rule on our top pick, here are some honorable mentions.
The Planned Parenthood League of Connecticut's executive director, Griswold, and one of its doctors, Buxton, were arrested and charged under a Connecticut law that forbade the use of contraceptives by anyone, including married couples.
Let me join the others in once again saying that today is a milestone in the long struggle to protect our children from tobacco.
We've heard that we couldn't survive before when we had 700,000 members and when we had 17 million members.
Evolution was about to go on trial with an unusual cast of characters. A group of civic boosters trying to put their little town on the map.
McCulloch versus Maryland entailed of necessity the question, who is supreme, the federal government or the government of the several states?
Number 1. Roe v. Wade.
He actually researched the history of abortion, and his visceral response was the state ought not to be telling doctors how to regulate pregnancy.
The Constitution is very clear on the laws of men, but it's somewhat hazy about women. In the midst of feminism's second wave, many women sought to control their own bodies and futures by obtaining the right to seek an abortion. The Supreme Court's decision stated that it was a woman's right to seek an abortion within the first trimester, although second trimester abortions could be regulated and third trimester abortions could be banned by the state altogether, citing clauses under both the 9th and the 14th Amendments to the Constitution, though these regulations have since evolved through other landmark cases.
But at the core of the case was whether or not they should overturn Roe v. Wade, the 1973 decision that legalized abortion and made a woman's reproductive choices a fundamental right.
This milestone ruling has been the subject of intense debate, and the issue continues to be contentious even in the 21st century.
My view is, regardless of whether you think prohibiting abortion is good or whether you think prohibiting abortion is bad, regardless of how you come out on that, my only point is the Constitution does not say anything about it.
Do you agree with our list? What landmark cases did we miss? For more top 10s about history and pop culture published every day, be sure to subscribe to
Very interesting. Like, particularly the last one, Roe v. Wade. It's still today used as kind of like a political football that they just, they use it to kind of point fingers at each other. Like, how can you vote for this person based on their stance, etc., etc. Court and setting precedents, it's just so important. And I think that, we need to make an effort to keep money, like lobbying, out of politics, because if you allow money to buy political influence, inevitably, the leadership of a country becomes less about the happiness and prosperity of the citizens. It just becomes about the prosperity of the businesses, and businesses don't often have, why would a business care about a population as long, the business just cares about its profits, its bottom line. So, and to be honest, the genie's out of the bottle. Lobbying has long been legal and will probably never be made illegal. It's probably impossible. So we need to just keep constraints on it, We just need to be careful with it. But yeah, really, really interesting video. Thanks for watching, guys, and I'll see you in the next one. Please help me out by liking and subscribing.